Welcome to our Latin American Digital and Data Protection Update. Thank you for being here today. My name is Guillermo Larrea. I will be your host today. I'm based in Mexico City and I lead the cybersecurity, privacy, and data protection practice with focus on Latin America. Our team has helped in countless investigations, digital transformation, and digital compliance. Thank you so much for being here today. A few virtual reminders. This session will be recorded. Keep your microphones on mute. After our keynote presentation, we will have a conversation between experts about Latin America. We will be taking a few questions to our panelists, so please feel free to comment in an open chat during the course of the experts' participations. Because of the numbers of speakers and panelists that we have today, there will be no room at the end for more questions, so please do not wait until the end. Tuesday will provide a synopsis for event, so and we will be sharing this presentation to you. And this is a first of a series of events, discussions about Latin America. So please stay tuned. So we have great contents for you in the coming weeks. As an opening remark, I would like to say that Latin America presents a complex reality. The region is in the edge of digital conversion, a step which was slowly developing compared to Asia, I have to say, and Europe, but that took momentum in the aftermath of COVID. At the same time, the region lives agitated political scenario and a diversity of laws and regulations, GDPR-oriented, with a very different legal regimes. Efforts have been taken, like with the Red Iberoamericana, but the profound transformation is evident after COVID. Now everyone and everything is digital in Latin America. To understand better our context, our keynote will provide more views into a global perspective, key global cybersecurity, cybercrime issues on this era of digital transformation. The idea of this webinar is that you take away from this session more context on the global landscape on cybersecurity and data protection, understand where is LATAM in digital and data protection development, recent new pieces of legislation and enforcement cases, and of course, some of the initiatives of the region. To talk about this today, we have a number of friends and experts of Jones Day and our business partners across Latin America. Amy Burkart, she's the former chief of cybercrime unit at the United States Attorney's Office in Boston, Massachusetts, where she spent a decade investigating and prosecuting computer, intellectual property, and financial crimes. Amy is an experienced trial lawyer who directed investigative teams from the FBI, the Secret Service, Homeland Security investigations, just to cite a few. She is our keynote speaker, and thank you, Amy, for being here today. And to share with you your knowledge. Paulina Silva is the director of the Data Protection and Technology Contracting Group in Carey, Santiago, Chile. Her practice area focuses on technology contracting, negotiation, and legal advice on licensing, software, implementation, and maintenance projects, as well as data protection and cybersecurity. She's one of the founders and is currently a board member of the Chilean Cybersecurity Alliance. Paulina, thank you so much for being here as well today. Pablo Palazzi is partner of Allende, Brea in Buenos Aires, Argentina, and a legal expert in data privacy law. He has written 3 books about data privacy and several articles, and he advises regularly international companies on data protection issues in Latin America. Pablo, welcome, and thank you for being here. Eduardo Pieri is a partner of intellectual property, data privacy at Barbosa, Müsssnich, Aragao in Sao Paulo and Rio de Janeiro. He is an expert in privacy and cybersecurity, and he has advised companies on the implementation of the new Brazilian data protection law. Jose, welcome, and thank you for being here. And finally, but not last, Jose Bermudez. Jose Bermudez is a partner in privacy data protection at Bermudez, Durana, Abogados in Bogotá, Colombia. He's an expert in privacy and a personality in the region. Jose, thank you for being here as well. So without any further introduction, Emmy, please, the microphone is yours, and let's kick it off.
Great, thanks so much. It's terrific to be here. If you could move to the first slide, please. I'd like to start by just talking a little bit about what cybercrime is. It's a definition that's evolved, and I think it's important to sort of frame it. I've done a shout out to my first computer here, the Apple IIe with the floppy disks. It would have been pretty hard to, I think, commit much of a cybercrime on that, maybe some accounting fraud. But the dial-up modem really changed that. And for a while, anything that happened on the internet was considered a cybercrime. Certainly in the federal law enforcement world, it was a very broad umbrella. That's changed and evolved as the world has changed and evolved. I have a photo here of the Seizure of Alpha Bay, which was a coordinated effort with FBI, Homeland Security, and DOJ, and a number of international law enforcement partners, which was one of the dark web marketplaces selling child pornography, and drugs, and those kinds of contraband. Selling contraband is in and of itself not necessarily a cyber crime, if you think of that as something that is as old as there is contraband. But in many ways, there's a fundamental difference when crimes are committed on the internet. So as the definition of cybercrime has evolved, even during my 10 years as a prosecutor investigating and prosecuting these crimes, there has been a bit of a almost a shift or a tension with some people thinking, you know what, at this point, everything is essentially a cybercrime. So that's just a means to facilitate another crime. And the definition is sort of been changed by the fact that there's been such an explosive growth. I understand that position. I do, though, think if we do that, we risk focusing on what cybercrime is, why people are committing it, and we risk losing focus. And I think in many ways, the significant threat that's posed by cybercrime is one of the biggest global threats that we have today. So I would suggest that what we need to do is just understand it, think a little bit about the different reasons why people are doing it, and then that will lead us to the best ways to combat it. So in my mind, I really group cybercrimes into the motivations for why people are committing it. So if you could move to the next slide, please. Motivations for cybercrime, like most crimes, are as old as human nature. So back to the 7 deadly sins, I put one sort of big bucket of cybercrime in the cyber financial crimes. So basically cyber-enabled fraud schemes. Fraud schemes, money laundering schemes, ways to get rid of or be able to make the fraud scheme proceeds usable, make up the most significant portion of cyber crimes. Our largest buckets are what we call business email compromise. Those have grown exponentially during the time that I was working in the Department of Justice, and they've grown globally. So everyone is a potential target. We see significant sophistication coming out of these crimes. In the early days, these were pretty easy to spot. People were sort of alert to the idea that these kinds of schemes were, fraud at the core. But they have now become increasingly harder to spot because they're usually married with other types of cybercrime facilitators. So for instance, we see a lot of infiltrations into businesses, into real estate companies, and then that allows the cyber threat actors to send very targeted emails or very targeted requests, and they're becoming increasingly sophisticated. They're asking for the right amount of money. They're asking, using the right names. They're using right transaction information, but they're having funds diverted. And that's a $1 billion problem, and one that many very smart, intelligent, well-trained people find themselves falling prey to because of the increased sophistication. We also see those crimes facilitated by extensive money laundering networks. Often here in the US, those are the people that are physically here, physically present, are the money laundering networks. And those are often work from home schemes, romance fraud schemes. Again, these are becoming increasingly sophisticated as well. And many very sort of savvy people are falling victim to them. And that's allowing significant amounts of money to move through accounts very quickly and then move out of the United States, and makes it a lot harder to get. The economic conditions for business email compromise are particularly troublesome right now. We see a lot of activity of threat actors involved in this, individuals involved in this, who are young, who are comfortable with working with the internet, often have easy access to the internet, but don't have good job opportunities. And so this becomes, in many ways, a dynamic that allows them to start considering business email compromise and other schemes as a way to fund their lives. And often, even even if there's multiple tries, multiple hits, and only one of them takes, that's enough to significantly fund their life much better than getting a job in the countries that they're in. So we're seeing Nigeria and South Africa have a lot of schemes coming out of that type of fraud. And there's a lot of crossover. There are some countries in Latin America that might be particularly prone to this, where there are a lot of access to the internet as job opportunities become tougher. Certainly in the US, as COVID has led us into a recession, I think there are many people who will be potential money laundering perpetrators. Some of them think that they're legitimately involved in a work from home scheme. Some of them are willfully blind to the fact that things are not adding up and shouldn't add up. But I expect that will increase. It's increased exponentially, and COVID should push that even further along. There are other types of financially motivated crimes, and many of them involve, again, a sort of a host of foreign actors and US actors. We've seen my colleagues in New Jersey prosecuted a group who out of Eastern Europe was hacking into different companies, getting information, and then trading off of that information, including by getting information available to third parties, such as the Newswire firm that put out the press releases announcing mergers and acquisitions, things that would move the stock price. Getting that information allowed people to trade ahead of that information becoming public, and was a way to commit a financially motivated cybercrime. Another big bucket that we see, and that's sort of a broad brush of the types of financially enabled cybercrimes that we see. Another big type is theft of intellectual property and theft of data. Sometimes that is also for financial purposes, theft of data to be resold. For instance, credit card data can be resold on dark markets. But more broadly, we also see theft of intellectual property by certain countries, sometimes to, for instance, give a competitive advantage to private companies in their own home country. Some people say the big three, some people would say the big four, but the advanced persistent threats, the APTs in this space, are generally China, Russia, Iran, and North Korea. And we've seen significant activity aimed at not just the US, but other companies and countries to steal intellectual property and to steal data. Sometimes we believe for intelligence purposes, so to build databases of citizens of other countries, that type of activity. So I think of that as the sort of in the broad envy bucket. Another type of cybercrime that I won't dwell on, but I think is worth mentioning because I find it particularly troublesome, is motivated by personal or political, not political in the global sense, but political in the more personal sense, crimes. And I put that under the wrath or anger or sort of individual motivations. We're seeing an increase of individuals and even businesses use these cyber tools to advance their motives. So for instance, there was an individual here near Boston who had read online about a child custody dispute where he thought that it was handled incorrectly. It was a medical situation where a girl was removed from her parents' custody by a judge and doctors. He didn't know the woman. He just read about it online. He felt that parental rights were important, and he organized a large group of people to launch a DDoS attack, a distributed denial of service attack, against a world-renowned children's hospital here in Boston. It knocked them off the internet. It took Harvard off the internet and all of the hospitals associated with it. And it had significant risk of patient care. There were a number of online tools for dosaging of medications, for sharing of records. They were unavailable. And that's just one person with one individual motivation that had an enormous effect on business and the health and safety of others. We're also seeing increased instances of cyber stalking, individuals engaged in cyber stalking. We prosecuted a number of those, obviously very impactful for the individual, but also can be impactful for the community. One of those cyber stalkers did a number of bomb threats and hoax school shootings as a way to retaliate against the community that was investigating him. And I actually, right before I left the department, did an investigation of a group at eBay, which is a public company, who had been together collectively at work engaged in a cyber harassment campaign against a journalist that they believed had unfairly covered eBay in the press. So while I don't think that it's going to be a trend for public companies to engage in cyber stalking, I think that the cyber tools that are available to engage in crimes, unfortunately, you're going to see a lot of people who are feeling negative emotions take them out on others, businesses, individuals, through these means. So that's sort of the what and the why. If we can move to the next slide. The how are mechanisms that really cross the different types of cybercrime, but these are sort of the big global TTPs, tactics, techniques, and procedures, and attack vectors that we see people employing globally. This charming photo is my 3 children fishing in the more traditional sense of fishing, but phishing by sending emails and links is still a very popular way. It's the #1 way, really, of creating intrusions. And again, people are getting more sophisticated. They're getting better about not clicking on links and opening attachments they don't know. But the bad actors are getting better as well. They're targeting those emails. They're targeting they're using information that they have to make it more likely that people will click. For instance, we've seen a significant increase of COVID-related spear phishing attempts. So the kits that are used, the codes are like fairly short codes. They're available online, and all you have to do is customize them. And so they're customized with the issues of the day. So now we're seeing, COVID-19 update, COVID-19 death in your area, things that people who are stressed and who are distracted and tired and interested in learning more may click on. And if that appears to come from the World Health Organization or another trusted source, as some of the ones we've seen more recently have, then they're more likely to be successful. Ransomware is another big and continuing threat, and we've seen a real increase in that recently. Many of you probably remember the 2017 WannaCry, and then NotPetya, which was actually not really ransomware. It was a malware sort of disguised as ransomware. But that's when that really broke into the global scene and caused significant global destruction. I've done a maze here because one of the most troublesome ransomware strains that is prevalent now is one called Maze, where the bad actors who are constantly evolving have realized that some companies have stopped paying ransomware because they're backing up their data, which is the advice that cybersecurity professionals give. So the Maze strain, the bad actors extract the data first, and then they encrypt it. And then the pressure is on not only to get your data back, but to the extent that a company could say, you know what, we don't need it, we're not paying, we're going to walk away, we've got it backed up. The Maze strain actors say, you know what, we're going to start releasing it publicly. And they'll put up websites and start incrementally releasing data that they've taken. So now it's not just about getting your data back, it's about keeping your customer data or your sensitive trade secrets private. And that really increases the pressure and the leverage on companies. And the last piece I have here is across the board, if you've got the key, that's the best way to get in. And so we're seeing that as really the #1 way still for people to get in. Sometimes that's through spear phishing. They're able to hack and get credentials, and they just use those credentials to get right in. Sometimes that's through what's called credential stuffing, where a database of many, many usernames and passwords is just run against a place that someone wants to get in. And if that person has used that password before and the username, that can provide the key in. There's a number of different ways where insider helpers have assisted people with getting in, sometimes wittingly, but often unwittingly through social engineering. Those techniques have gotten much better. And so we're seeing people who think that they're helping a customer or think that they're doing something appropriate, allow bad actors right into the system. So that's the what, the why, and the how. I think the who is really wrapped up in the why. If you're going to break bad, there's a type of cybercrime for you, and there's a motivation for you, whether you're a global entity or an individual. The where is everywhere, and the when is all the time. So I think that takes us back to what are we going to do about it? And that would be my last slide. The United States has a sort of a patchwork of different approaches to cybercrime and data privacy issues. On the federal side, we have a number of law enforcement agencies who are involved in fighting different kinds of cybercrime. I put up a few: the Federal Bureau of Investigations, the FBI, Secret Service, Electronic Crimes Task Force. They're actually reorganizing themselves, kind of back to the definition of what is a cybercrime, and combining with another group of the Secret Service, and they do a significant amount of work in this area. The Cyber Infrastructure Security Agency, Homeland Security, they all have their different type of cybercrime, some of them overlapping, some of them more specialized, often organized around who's the actor and what is their goal, for instance, nation state actor versus individual actors. One thing worth mentioning in that area is we're seeing an involvement of hybrid actors. So, for instance, nation state actors who are hacking on behalf of a nation state to get intellectual property, then also engaging in financially motivated crimes on the side. We're also seeing more what we call crime as service. So people who have one objective, hiring hackers or hiring a coder to help them fulfill their objective. In Latin America, I understand through law enforcement that there have been increased reports of drug cartels hiring hackers to assist with money laundering involving cryptocurrency. So in many ways, it's just like the business world where people develop specialties and then they turn to others with their specialties rather than be a one-stop shop. We're seeing various criminal cyber actors offer their services to other types of criminals. I've put up the shields of a couple of the attorney generals who are the most active in this space. They, in some ways, are similar to the federal actors in terms of fighting certain types of cybercrime, but in other ways are very different, and that's primarily with data breaches. In the federal government, data breaches are viewed as something where you're trying to find out who the bad actor is that has committed the data breach, who's taken the data. The companies who hold that data are generally viewed as victims. For the state AGs, their focus is protecting consumer privacy. And so they will take a very hard and skeptical look at a company who has had their data compromised, thinking of it as belonging really to the customers or to whoever sort of the ultimate owner of that data is, the holder of that information, the PII, personal information, and they will be looking for whether they took reasonable steps, not so much seeing the company as a victim, but more thinking of it as the individuals whose data was stolen as a victim. And the last piece I think worth mentioning is, I think, a hopeful one. We saw during the time that I was at the department, I saw more of a shift toward private-public partnerships, more of an awareness of the need to share threat information, not only between the private sector and the public sector, but also globally across the networks. The Department of Justice has a global network of prosecutors, and we had prosecutors who focused on cyber and intellectual property crime stationed all around the world. And I think that, companies like the ones that panelists belong to, law firms like Jones Day that have a global presence, at events like this one where people are sharing information and developing partnerships, those are really the best way to combat cybercrime. The bad actors don't recognize the borders between the countries. So to combat them, I think we need to work together and, across borders ourselves.
Thank you so much, Amy, for initial words and providing us context. Let me ask you this question. If you were to say one thing to a Latin American company, one thing in the context we're seeing globally on cybersecurity, data protection, about what they should be doing or what they should be thinking in terms of mitigating these risks and this this global scenario, what would you tell to the legal counsel of this company, to the people managing this company in this digital transformation process?
I think I would say that the advice of what to do for good cyber hygiene is out there. The challenge is always the people, but that's also the answer. So educating people, empowering them, helping them understand that companies of all sizes, individuals are all potential targets, but that in many ways there are low-hanging fruit things that everyone can do. Sometimes people don't recognize the threat at all. Sometimes people recognize the threat so much that they seize up and they don't do anything. I think working with your people to help them understand the threats that your company faces, to secure the most important of your trade secrets, to start working together to secure your data, and to recognize that, well, people are sort of your weakest link in terms of insider threats or allowing in phishing. They are also your biggest asset in terms of combating cybercrime. So work with your people to do that.
Thank you. Thanks again, Amy, and I encourage you to stay here to helps us make questions to our the group of panelists we have here today, and learn more about Latin America in the next few discussions. Thanks again.
Great.
Let me just turn very quickly and let's start our roundup on Latin America. I have here this slide. In Latin America, your privacy matters. Consent is more than a yes or no. We live in a very complex reality in the region with a number of different regulations and a very different types of government, I have to say. Paulina, talking about Chile, I understand a bill of law in the Chilean Congress seeks a deep change to the current applicable privacy law in Chile. Can you let us know which are the most relevant changes that companies should expect once this regulation is passed? When is it expected to be issued? Thank you again, Paulina, and welcome.
Thanks, Guillermo, and thank you and Jones Day for this invitation to be a part of this panel. Yes, a bill of law was introduced in the Chilean Senate in the beginning of 2017, 3 years now. And now it's on its final stages before the Senate and has been subject to many changes on its path. But after its approval, or after it's approved in the Senate, it needs to be reviewed by the Chamber of Deputies before its enactment. The bill seeks to increase the protection of privacy to basically fulfill international standards and to meet the challenges of a digital economy. But the actual initial driver, the first push to the domino, if you will, was really the pressure to meet the guidelines of the OECD. The complete inability of our current privacy law to meet any modern standards in terms of privacy is no secret. The current Chilean privacy law dates back to 1999. So as you can imagine, it was drafted with a completely different scenario in mind, a different paradigm. So having said that, these are the main changes on this bill of law. For one thing, it creates a data protection agency. Today, breaches have to be taken to court, and the burden of proof lies completely on the data subject. So as you can imagine, there are very little economic incentives for data subjects to just take a breach to court. Originally, this bill of law created a brand new agency, but then the Constitution Commission approved the government's proposal so that the Transparency Council will fulfill the role of a data protection authority. Today, the Transparency Council in Chile is actually the data protection agency, but only oversees public bodies, and it has very, very limited powers. This agency will have the authority to monitor and to punish violations of the law with fines of up to 10,000 monthly tax units, which is equivalent to approximately $600,000. But if you compare that highest fine to the highest fine today, which is only 50 monthly tax units, you can see that the highest fines are multiplied by 200. And actually, that highest fine has never been issued ever. So it's very evident how little the breaches of this law actually reach court. The bill also, I would say that the second largest change or most important change for companies is that it creates a whole new structure around security, which will actually become the very first transversal cybersecurity obligation in Chilean law. Our privacy law today does not provide for any security obligation whatsoever. So any negligence from the controller to adopt security measures following a breach will be punished either by sector-specific regulation, like the one applicable to banks and financial institutions, by the Consumer Protection Statute, if it's applicable, or theoretically by a breach of the obligation of a controller to process data diligently. And this, again, has never been tested in court. So what the Bill of Law does in terms of structure around security is that it creates a general security principle. So that will be applicable to the interpretation of the rest of the law. On second place, it creates an obligation to adopt organizational and technical security measures, much like GDPR does, and an obligation to notify the breaches to security measures to the agency and directly to the data subjects if the breach affects financial or sensitive information or data belonging to minors, to underage subjects. So the bill brings many other changes, but if I had to choose, I'd say these two are the game changers for companies. There will be enforcement, because there will be a data protection authority with the powers to impose fines. And cybersecurity will not only be a nice to have, but a legal obligation for anyone who processes personal data.
Do you think, Paulina, the landscape change the COVID-19 lockdown, do you create the obligations for authorities to push harder the new bills and the new initiatives, or do you see basically the same path, just with a different scenario in the market?
I wish I would see more of a driver from the authorities to push this bills of law pertaining cybersecurity as a consequence to COVID, but it's not a trend, or it's not a very powerful trend that I'm seeing right now. However, Chile is no stranger to these sort of challenges, unfortunately, and the powerful social unrest that began to unravel on 9 months ago, on October 2019. I would say that is working more of a strong driver to push forward legislation that is more citizen oriented, and in that sense, or along that structure. And now it's probably wishful thinking, but I imagine that at some point there will be, that will mean a driver from the Congress or the government to push this legislation that actually ends up being very protective to citizens, not only data protection law, but a new a bill of law that is also being discussed in Congress on cybercrime. And the government has the power to speed up the process of discussion before the Congress. Also, the government has announced 2 bills of law. It hasn't filed them yet before Congress, so these are just announcements of a cybersecurity framework law and a law on critical infrastructure. So we're actually very much looking forward for that to become at least a bill of law, and then see what it's all about. So
I ask you this. I mean, we know for a fact, a number of financial institutions in Chile, so as in Mexico and other countries in the region, have been subject to cybersecurity attacks and have been subject to some kind of hacking or cybersecurity activity. Where do you see the reaction of the companies in terms of police collaboration, and at the same time with the new piece of current legislative scenario? I mean, how are companies reacting in this evolving world of new pieces of legislation at the time that we are seeing, in fact, that financial institutions are being attacked?
The first pieces of legislation, or at least sector-specific regulation, were reactive, were issued right after the large May 2018 attacks to banks. Around the time, actually a bit before that, the cybersecurity environment was already, in the move. I would say that there is a healthy cybersecurity industry that has developed not thanks to legislation, but despite the lack of regulation. So companies are investing in cybersecurity not because it will be expensive in regards of fines for non-compliance, because they don't have a natural obligation to keep their system secure, as strange as it sounds, but because they need to protect their assets. So the reactions that companies are having, or the money that they're investing, does not necessarily relate to being afraid of not complying with a specific legal obligation. For instance, if we talk about how the private sector has reacted to this, a good example on how it has started to get together and organize the creation of the Chilean Cybersecurity Alliance in 2017, which is a group of now 11 institutions from the educational area and business and technology, and several chambers of commerce that seek to actually work as a link with the government to have a voice from the private sector to educate and to discuss cybersecurity matters. So it is, to sum up, the environment. I see that the environment is actually moving faster than the regulation and legislation. The only piece of sector-specific regulation today is the regulation on banks and financial institutions. And strangely enough, it provides for an obligation to notify cybersecurity incidents within 30 minutes. Yeah,
30 minutes.
30 minutes.
Wow.
Yeah.
Not very realistic. I don't know how you manage that. That's a crazy timing.
What hit you? You don't know what's happened in 30 minutes. Like how could you ever actually realize if you've been under a cyber attack, or you just dropped a pen drive?
Absolutely, but as you mentioned, it is sort of the same scenario here in Mexico. Because of a number of hacking activities, the intervention of the National Banking Commission has been key in the development of further data protection and cybersecurity regulation, also requiring notification to the central bank and to the authorities. But timing here is of the essence. We will get back to you, Paulina. Let's keep going, the conversation going. Let me just turn very quickly to Pablo. Pablo, you have you've written a number of books. You were an expert in privacy throughout Latin America. Just very briefly, I mean, how to regulate data privacy online? Can you give us just a very quick overview on where the regulation stands in Argentina?
Yes, sure, Guillermo. First of all, thanks, Jones Day, for inviting me to this seminar. Argentine case is a very interesting case because it shows how a country can evolve in data privacy and adapt to what is changing. As most of you know, Argentina enacted a data protection law in the year 2000, and the law is based on what we call the European model. So it's based on the European Directive of 1995. It was one of the first countries to become adequate through an assessment of the European Commission, and together with Uruguay a bit later. And so because it's follow 1995 directive, it's not GDPR updated. But because of that, Congress 2 years ago prepared and drafted a bill by the executive power to adapt Argentine law to the GDPR. The bill has not been approved yet. But despite this old model that has now 20 years of existence, the Argentine regulator started to enact a lot of small regulations to fill the gaps and make it more GDPR compatible. I will explain this a bit more. So the first thing that happened was that the past government took the DPA, which was located at the Ministry of Justice, and put it under the Freedom of Information Agency. So the Freedom of Information Agency is an independent agency from the government, so they are autonomous, and because of that, now the Argentine Data Protection Agency is also autonomous and independent from the government. which, as you know, is a key element for European regulator to consider your country adequate. And the second thing that happened is that in the last years, the DPA has been enacting several regulations. For example, they requested that all government agencies to have a DPA. They created a data breach regulation, which is not in the law. They enacted, together with the DPA of Uruguay, a joint document establishing their requirements for a privacy impact assessment, which is not in the law also. And last year, they also enacted contractual model clauses for international transfers and a binding corporate rules regulation. So at the end, if Argentina is not GDPR compatible because the law is 20 years old, what has been happening is that little changes in the law has been adapting Argentina to what is only the de facto in European data protection matters. No? So that's the status of Argentina. We started as non-GDPR, but now I can say that we are kind of GDPR compatible.
Right, and I remember Pablo a few years back talking with Eduardo Bertoni, the head of the Data Protection Agency in Argentina. We had an incredible discussion about how the country was moving from a data protection regime to a cyber, to an increasing review of cyber issues. But at the same time, the struggles that this represented in terms of budget and in terms of equipments from a unit of the nature to actually perform this kind of reviews. How does Argentina regulate cyber crimes? And where is Argentina in this regard? And are you seeing the same kind of thing that Paulina described in Chile?
Yeah, more or less. I think we have a huge change in the year 2008. As you know, in criminal law, in most civil law countries, have a canon of strict interpretation of the law. So you either have something which is a crime or something which is not a crime. If it's not in the law as a crime, it's not a crime. And you can't apply analogy to interpret, or you can use elastic interpretation to apply, to say, for example, theft of data is not in the law, but because I can steal an object, I can say that I can steal information. That's provision by the Constitution and international treaties. So the problem for us was that until 2008, there were a lot of cases of virus, computer damages, theft of confidential data, which were not a crime. In 2008, in a case related with drugs, there was a hacking of emails of judges and journalists, and because of that, there was a huge discussion in the media, and Congress enacted a computer crime law, which I work in the drafting of this computer crime law. And what Argentina did is to contemplate several computer crimes like computer damage, computer fraud, hacking, illegal access to electronic communications, computer viruses, spreading computer viruses, denial of service attack, etc. And the approval of the law was not easy because a lot of technological companies were reading the bill with another view. For example, I remember Microsoft was opposing the bill because they argued that the computer damage provision was going to make difficult for them their anti-theft or anti-copy software. Remember that if you don't pay the license and you use a Windows system, the computer will froze and we detect that it's illegal. And they say, well, but if I stop a computer working, I can have a criminal case. Finally, I think it was a matter of reading it. Some computer experts said, well, but I won't be able to use a spam filter because if I delete an email, which is a spam, I can go to jail. Well, it was a huge discussion, but I think finally the computer and the technology industry understood that this was nothing different from what has been approved all around the world. And a few years later, Argentina joined the Cybercrime Convention, the Budapest Convention, which was a bit of symbolic because already the bill that we discussed and drafted and approved in Congress contemplates all computer crimes that are in the convention. But what's important here is that Argentina has been participated in the Octopus Conference, which is a conference that takes place around the Cybercrime Convention every year. And after that, Argentina created a prosecutor agency for computer crimes at the federal level. and also one at the city of Buenos Aires, and more several in provinces, and it's very active, and they're having a lot of cases, and they have a 24/7 system that you can report crimes, and also they have created units at the federal police level and local police level to prosecute computer crimes. So probably the only deficit, I would say, is the procedural amendment of laws to contemplate criminal evidence, authorized hacking by a judge to enter a computer without entering a home, and all that stuff, which is coming and is being discussed, which has a lot of policy issues because every time the government wants to regulate that, people get very uncomfortable and start discussing what are the limits of these new tools. So that's the state in Argentina.
Thank you, Pablo. Let me ask you this question. I mean, what has COVID-19 brought into the Argentinian arena from a data protection perspective? Meaning, what has the authority done with respect to COVID-19 in privacy and data protection issues? And also, if you can just spend 1 or 2 minutes describing how did the landscape change on cyber crimes during the pandemic period?
Okay. Well, what's happening is that most companies move to remote work. Employees are at their home, and all the companies were thinking about working remotely, but none of them implemented, and they were forced to do it. And when they did it, well, there are a lot of issues about securities because one thing is that you have information in your computer in the company, and other things to have it in different places. So security has been weakened, I think, and one of the results is that we've seen, especially in the first 2 months of the lockdown, we in Argentina and in Buenos Aires, today we have 125 days of lockdown. That means because of COVID, so we cannot go out of our home. So we are working remotely, but of course, criminals are using this, and there has been a lot of cases of ransomware where the software will get into a computer and there will go through the networks. And I have 2 clients whose computers has been encrypted for 30 days, and the companies, I'm talking of companies of 1,000 employees, 2,000 employees, were not able to work. So we filed criminal complaints, and of course, we didn't pay ransom, but because the ransom was huge. For example, 1 week ago, telecom company was attacked, which is the main telco in Argentina, and the ransom for the key to the crypt was in Bitcoin, $7.5 million, which is a lot of money for a company to pay. And so this is very complicated. This is one of my clients, but my clients didn't pay also. But also we detected that from Poland, for example. So Poland is from Argentina, and during COVID, investigating that is very difficult for prosecutors. So what we are going to do, we are using criminal law, we are using civil law for computer damages. So we are going to sue the companies who are in charge of security and were not able to prevent this. And probably what's happening now is that I see a lot of scam online and fake news also going around because people are worried, and criminals use that to create fraud on people and take out money, for example, for certain cures which does not exist. So it's really increasing a lot, cybercrime, a lot, and a lot of targeting using information from the internet, from your Facebook account, etc. I think that, and if you see, I follow the accounts of the criminal prosecutors in Argentina, and they all issue warnings every day for different threats. So it's really been increasing a lot during the pandemic, the cybercrime. So and it's difficult, to investigate this. There has been a lot of cases related with revenge porn, distribution of child porn. They have increased around 3,000% of crimes also. So prosecutors are very busy in Argentina investigating all these cybersecurity issues. So that's all. And to finish, cybersecurity has been also on the agenda of the government. And 2 examples are that 2 fines that the DPA, the Data Protection Agency, imposed for that breach. One was to Yahoo. Yahoo have a breach, and the case took a lot of time in Argentina. I don't know why. And a few months ago, they imposed a fine against Yahoo for this data breach, Yahoo Argentina. And the other data breach was against the police, the federal police, which has a huge leak of information, like 4 terabytes. And of course, the files were going all around the deep web, and the agency said that they could impose a fine on the federal police because it's part of the government and they're part of the same government. It will be like in money from one place and move it to another place within the same agency. But they issued 3 warnings to the federal police and asked them to amend the security systems to avoid having data breaches in the future. So that's what's happening now in Argentina. If you, I'm available for questions if you want, have any doubt.
Thank you, Pablo, and we'll get back to you with a few other questions. In advance, I want to ask you about the enforcement. Let me turn to Jose Eduardo, but just think on this question, and we'll get back to you later on the enforcement. And perhaps this is a question not just for you, but for everyone else of our panelists. As you know, one of the big critiques, of us experts into the regulation in Latin America is sometimes the impossibility or the lack of enforcement cases which are actually successful and that end up in fines or criminal prosecution in regards to data breaches and cyber crimes. So I guess the question is, how has this changed over the past few months? And is the Argentinian law allowing additional fines? Just keep that give it a thought for a second, and let me turn it to Jose Eduardo. Jose Eduardo, from our expert from Brazil. Brazil has created a lot of expectation in the last few months because of the multiple changes if it's becoming the entry into force of the data protection law or not. It has confuses all of us in the Latin American region. So, Jose Eduardo, let me ask you, where is Brazil in terms of the data protection law? Is it becoming enforceable in August? Is it, when do we have an entry into force? Can you let us know, please?
Well, Guillermo, thank you very much. I'm very honored to be here in such a high quality panel. And thank you for John's Day for the invitation. Well, your question is the $1 million question for Brazil right now. I would love to have a clear-cut answer to it, but unfortunately, we do not have that. But to try to explain what's happening in Brazil, we had a law pub, the Brazilian Data Protection Law, the LGPD. It was published in August 2018, and it mirrors the GDPR. So very similar, well, not totally similar, but very close, especially regarding the rationale to the GDPR. And we had, firstly, a vacatio legis of a year and a half that was postponed for an additional 6 months. So the law was to commence in August 16, 2020. This means a month from today. However, with the pandemic, there were several bills and provisional measures regarding urgency aspects of the Brazilian legal scenario. And one of the aspects that were addressed was the commencement of the Brazilian law, data protection law. Because what happened was a big lobby from companies saying that, look, we're now at home, we're cut with resources, and we need more time to prepare. We can't be expected to be totally compliant with the law in August. So in March 2020, there was a bill of law that then became law. And the first thing that it did was regarding data privacy was it postponed the administrative sanctions to August 2021. So there will be an additional year for companies to before they could be fined from the administrative body. Okay, so the data authority, the local data protection authority. On top of that law came provisional measure that not only changed the date, well, it maintained the sanctions to August 2021, but postponed the commencement to May 2021. So currently, today, as we speak, the commencement date of the Brazilian data privacy law is May 2021, May 3rd, 2021. However, as things in Brazil are not that simple, this provisional measure, it must be voted by Congress by the end of August. If it's rejected or simply not voted, this means that the provisional measure no longer exists. And the commencement date returns to August 16, 2020. So kind of back to the future. We're going to be in the end of August, and the law has been enacted. Well, the original date is August 16. So this is how we stand. There is lots of lobby from private sectors to maintain and vote the provisionary measure so that the commencement date is May 2021.
Okay, I see. I don't know. It is indeed complicated to follow up on this, but thank you for this clarification, Jose. Do you think the COVID-19 pandemic accelerated any provisions on privacy under the new legislation or court decisions?
For sure. During this period that the postponement of the law, what happened was that another provisional measure issued by the government determined the telecom operators to disclose personal information, specifically name, address, telephone number, for the National Census Bureau, so that they could maintain their census, their research regarding especially unemployment during this period. And several political parties, the Brazilian National Bar, question constitutionality regarding this made out on the scope of provided by the federal constitution. Guarantees the right to privacy, but the Supreme Court went a step ahead and understood that what the Constitution protects is not only the right to be left alone or the right to intimacy, but it's much more. It's the right for a data subject to know what data is being treated and for what purpose, and what are the rules of data security. What can be enforced if there's a problem. So I would say that this is, it's not new legislation, but for sure, when you have the Supreme Court interpreting the Constitution to beyond what we had as a general concept of privacy, this was something triggered by the COVID pandemic reality that we're living here in Brazil.
And I guess it's the same scenario in each of our countries. Finally, we see authorities that for a long time were reluctant to adopt, digital environments and even, to have court decisions on digital environments. We're seeing now a switch and a change in the process of COVID-19. I see Brazil is in the same scenario as well. Now, in terms of the Data Protection Authority, and without a piece of legislation still, or yet to become enforceable, Jose, who is the Data Protection Authority, or is there an authority taking the role of a DPA in Brazil?
Well, no, there is not. We do not have a data protection authority. The law establishes that it should be created. It grants the executive, so the president, to create this authority. But we have a president that was elected based on low spending and cutting costs. So this means that we did not have, prior to the COVID system, well, till this day, a data protection authority constitution. The public prosecutor's office and consumer protection entities, they have invested themselves of powers to question issues regarding data protection. So we had, I can bring two cases that I would like to share with you. First, Netshoes. That's one of the biggest, well, it was the Brazilian, the biggest online retail store in Brazil. And it went through a big data breach. And what the public prosecutor's office did was that it required Netshoes to contact all the data subject that had their data exposed. They could do this by registered mail or by a data center. And Netshoes did put up a data center, a call center, I'm sorry, excuse me, a call center, and called every single one, although we do not have any obligation in the current law stating that you have to notify when there's a data breach. So the public prosecutor's office did this. And the other case was Banco Inter, which is a digital bank that also had data exposed. And what happened was that the public prosecutor's office reached an agreement of R$1 million. Now we look at R$1 million, and I would say with the currency today, it would be 2,500. $2,500 US dollars, and it's not much, not even for Brazilian currency, regarding the scope of a data breach. But it was the highest fine, well, not a fine because it was an agreement, but it was the highest penalty, if we can say that, granted up to this date. So these were two cases that I would like to bring that were enforced in spite of not having a data protection authority.
I see. Thank you so much for these enlightened cases. Jose Eduardo, let me just turn now to our folk in Colombia. I'll get back to all of you. I do have some questions for all of you to jump in, and it seems that we will have some time at the end, towards the end, to discuss further. But Jose Bermudez, I mean, the Colombian data protection regime seems very much like the Mexican data protection regime. Can you let us know how does the environment has evolved in this pandemic period about sanctions by the SIC, during this pandemic period? We would like to know if enforcement is moving forward, or there's a reluctance, there's more flexibility from the authority because we are just in a shutdown. Welcome, Jose, again.
Thank you, Guillermo. Yes, I would just let me start by saying that the Colombian DPA, the superintendents, has been from the start. So back to the enactment of the law in 2012, the superintendents has been a fairly active DPA in the region. They've been known to conduct a large amount of investigations. They have grown in size considerably since they started to act back in 2012 as a standalone section of the Superintendents of Industry and Commerce. And as part of that reality of the superintendency, the agency has also been active in providing guidance to companies, to organizations, as to how to make rational implementations of the law and how to implement accountability principle, international transfers. So there's been guidance on transfers, on e-commerce, on implementation of the accountability principle, etc. We've seen as a result of specifically of COVID, and just to go directly into that, we've seen the superintendents being somewhat active in doing audits on contact tracing apps. There's been a series of contact tracing apps deployed both in a federal government nationwide level as by some local cities who have deployed their own regulation or their own contact tracing apps. We are, as many other countries in the region, under formal declarations of national emergency and sanitary emergency that has given ground to enacting emergency legislation. And part of emergency legislation has dealt in prescribing obligations to companies as to recording employee data, health data, symptom data for employees, and then reporting that information either in apps or directly keeping logs of information for the health authorities to be able to access them and make a contact tracing application. So we've seen an activity from the Superintendents of Industry and Commerce, the SIC, on contact tracing apps. This information has not been made public as to what the audits have concluded. There's been some calls to action for local apps and local governments, and then a basic clearance of the government app. We've also seen the superintendents working hand in hand with the local government and some state agencies and telco carriers to be able to provide or authorize the provision of data to the National Planning Department to be able to allocate resources for the most vulnerable population in the way, I mean, the National Planning Department has a means to identify the most vulnerable population, but there's no way to contact them. So there's been a work with telco carriers as to give temporary permission to access telephone data numbers to be able to contact these vulnerable population to provide health, to provide relief packages. So that's sort of what we're seeing from the authority right now. There's been a couple of additional guidances and activity in the way of starting investigations. We saw in April and May of this year, during lockdown for COVID, the start or press releases regarding the start of 2 investigations, specifically a TikTok probe and the Zoom probe on those applications. There's been a lot of controversy in Colombia as to the possibility of the superintendents of starting or initiating actions against companies which do not have a local presence in Colombia. The interpretation of the extraterritorial application of the data protection law has been given by SIC an ample interpretation. I personally believe that interpretation is overreaching, and there's no possibility of starting those investigations to companies which have not a local presence in the country, but that's open to debate up to when the courts make a decision as to where those investigations were really grounded in the law, and the law was able to be interpreted with that full reach. I would leave it there. I mean, I have a couple more comments on some guidelines, but just to keep it moving.
Well, I mean, this is fascinating, Jose. I mean, TikTok and Zoom, as you know, they are platforms well used across Latin America and in the world, especially Zoom. In the aftermath of COVID, everyone jumped in immediately into Zoom. We saw schools, everyone taking Zoom, and the fact that the Colombian authority began at least an investigation, well, that talks about the activity in the region. Now, the ultimate outcome, it's a different thing. Same like with TikTok. But let me ask you this in terms of as you know, everyone knows Colombia is also a hub for development of technology of a series of Fortune 500 companies. What is yet to come regarding cybersecurity in the Colombian market? What do you see in that end? And I'm asking this because we have a number of companies here that have either plans of investing or ongoing operations in Colombia, and I think it's important for them to know what's yet to come on the cybersecurity end.
Well, yes, I mean Colombia joined the cybersecurity convention as well. That they deposited those instruments in March this year. So there's been activity on that side. There's a national policy documents which are back from 2011, setting up coordination between agencies. Some of those actions have yet to be deployed. Those national policy documents, which are called COMPES in Colombia, establish a series of tasks to different agencies: Ministry of Telcos, Superintendency of Agency of Industry and Commerce, National Planning Department, etc., to make a coordinated effort to deploy cybercrime strategies and digital cybercrime prevention strategies. From a perspective of data protection and from the perspective of the Data Protection Agency, there's been a special interest in defining or trying to prevent identity fraud, and that's been a common issue in some of the decisions. There's an app which is used largely in Colombia, also growing immensely, for example, in Mexico, which is Rappi. Rappi had an investigation, which is not that new. It was last year, but there was it was based on the lack of response to a consumer complaint asking for delisting from the app and just an exercise of his data subject rights. And there were specific provisions in that decision. That decision set up ultimately fines for around $80,000 plus a series of orders given by the superintendency to modify procedures within the app. There was a specific call to set up procedures that allow for a complete identification of the consumer to prevent fraud and to prevent identity theft. So you can see that there's an interest from the superintendents of going into that particular category of security prevention and security considerations. That has also been included in a guideline for data protection in e-commerce, which makes a link to the consumer protection law, which is also under the scope of the Superintendents of Industry and Commerce, separate department, but same superintendent, so same government agency, of having full identification of consumer identity and an obligation to deploy security measures which prevent information tampering, disclosure of information to unauthorized parties, and that has to be leveled against risk levels of the company, nature of the data that's being processed, number of data subjects on the database processed by the company, etc. So there's a big effort and a big emphasis on that kind of information by the superintendents.
Thank you, Jose. Very, very interesting. Let's move into a quick roundup with our keynote speaker and panelist. Then I'll move forward with some brief issues about Mexico, and finally to some takeaways out of this presentation. Amy, turning out this to you, now that you see the discussions of our experts in Latin America, do you feel there's a different approach the US is taking towards cybersecurity data protection as opposed to what is happening in the Latin American region? I would just mention that perhaps there are less data protection laws in considering some state, that this is regulated at the state level, as opposed to what we see in LATAM, that there are a number of pieces of legislation, heavy pieces of legislation. It seems to me, at least from my perspective, that the US is more oriented on the cybersecurity protection as opposed to the protection of the data itself. Can you let us know your thoughts on this, please?
Yes, definitely. So I think, for better or worse, there are many examples of how the US is a very individually oriented society. And we have these sort of two layers of government. And you see that, manifest itself in a lot of different ways. So I'm in Massachusetts, in Boston. I think the differences between Massachusetts and Texas, for instance, or Florida or California are, I don't know, how many on the line have visited the States, but I think if you go to one of those states, you have an impression of what people in the US are like, and then you might have a very different impression if you're in a different location. So they're really, the laws are very much reflective of that. And we have the two systems of the federal and the state system in many ways overlapping and in some ways taking very different approaches. I think the fact that there's no federal privacy law and is why, when I was talking about sort of the federal perspective of the companies who have had breaches are victims, and we're focused on figuring out who's infiltrating data, who's infiltrating the systems and exfiltrating data, that's a very federal approach. And there are agencies, though, at the federal level who are looking at it very differently. The Securities and Exchange Commission, the SEC. There are industries that are very regulated, for instance, healthcare industries with the HIPAA laws. So there are federal laws about privacy, but they're industry specific, and there's not sharing between the agencies. The Department of Justice would not give information that they obtained in an investigation to one of the other regulators. So there's a real siloed approach even within the federal government. And then there's 50 different silos within the states, some of which have very robust laws about enforcing privacy rights that are similar to even the California law, perhaps even greater than some of the protections of GDPR, depending on what you're looking at. And then other states where there's notification requirements, but no privacy law at all. So there's a huge difference in how Americans approach things across the board. And that manifests itself through our cybersecurity laws as well. But it was very interesting to me to hear, that we're all in many ways grappling with the exact same problems, the exact same threats. We're just doing it in different ways.
Thank you, Amy. Thank you again. And in the same line of thinking, Pablo, mentioned a little bit about the regulation in Argentina. I was just making the reference before that while Argentina has a lot of provisions, I think part of the issue, at least in the past, was that the fines were very low, so there were not too many enforcement cases in Argentina, and companies were not being really fined, although prosecuted in some instances. And let me link this also with Paulina. That it seems exactly the opposite. It seems that Chile has a central government response team to security incidents, and it has focused more on cybersecurity as opposed to the data protection itself, which, as Paulina suggested, is on the works at this time. So let me turn this first to Paulina. Paulina, how do you see, or where do you see the success of Chile in cybersecurity, while not having a complex data protection law? And then let's go back to Pablo to explain us how is the finance environment evolved in Argentina.
Guillermo, I'm sorry, I couldn't hear the main part of your question.
I guess what I was trying to say, I was complementing the cybersecurity unit, so the cyber police in Chile, in a way that we think it's a success, and it has been doing, it has a lot of activity without a very complex piece of regulation on the data protection end. So how would you compare that to the rest of the Latin American legislative countries that have put more effort into data protection as opposed to cybersecurity?
Well, the situation in Chile is a great example. Unfortunately, it's a great example of how important it is to, in terms of legislative strategy, have effective means of enforcement. Because even for Chileans, there is this misconception that we do not have a privacy law, and we have one. From 1999, we haven't had one. But when you don't have a data protection authority, and when all the economic incentives are, placed mistakenly placed in the wrong spots, what you get is a law that has never visited the courts. There have been, of course, some cases that actually stem, or some privacy cases that actually stem from the Constitution. The Constitution was changed in 2018 to include data protection as a guaranteed right. So the actions following, non-compliances with the Constitution have seen a more rich development in case law. But we always have this underlying challenge with data protection law, in the way that it seems that the current driver for companies is actually gaining trust, for instance, or brand tarnishing, as opposed to actual enforcement from an authority that doesn't exist. Now, from the cybersecurity realm, if you will, the cybersecurity incident response team, CECIRT, has gained a very protagonist role recently. They, for instance, they're a department from the Ministry of Homeland and Security, and for instance, they have issued and is always updating this report on cyber risks related to COVID. The first one was a couple months ago, and they identified phishing, fake news actually, and fraudulent sites as the main threat following the pandemic. But then again, it seems very urgent for the structure, or the legislative structure, that we have effective means of enforcement, because otherwise the actual compliance with the law will still be low. Cybersecurity or privacy oriented.
Okay. Thank you, Paulina, again. And Pablo, very quickly, is there any change in the actual fine environment in Argentina? Is there a piece of legislation allowing the increase of fines?
Yes, there was a change when the new director, Eduardo Bertoni, took office. He realized that because the fines are engraved in the law, because of the exchange rate in dollars, the fines are very low. So he changed the interpretation of the law to consider that you can fine, for example, let's say a data breach. You have a data breach, a company has a data breach, and because of that, the company loses control of its database and 1 million registries, 1 million records. And instead of saying this is only one fact, and I'm going to fine you for one fact that you lose, you have a data expose personal data of 1 million people, he said that he can count each individual as a fact, so you can multiply the fine by the numbers of individuals affected, and that was applied already in a couple of cases related to the do not call registry law, and he fined with 1 or 2 million pesos some telcos, and that's been appealed because they say that it's not proportionate, and it's a way of interpreting the law to have more force to force companies to comply with the law. So that's on appeal, and we have to see what's going to happen.
Thank you, Pablo. Thank you. And thank you to everyone. We're approaching towards the end of our program today. I will take just a couple of minutes to discuss briefly Mexico, talk about briefly takeaways. And if the panelists have any final remarks, this is probably the time to do so. I will just, again, briefly talk a couple of minutes about Mexico. So in Mexico, the INAI, the Data Protection Authority, during the COVID-19 pandemic period has been very active. It has issued a number of recommendations. It created a specific microsite where everyone can share thoughts and review the information that and the public releases that the authority has created as a consequence of COVID. The INAI has reported more than 512 accesses to information request, which it's a change in the way people are seeing the protection of their data. From a market perspective, every company has a digital transformation initiative nowadays. Our clients are talking about these. Everything is about using social networks, launching apps, developing products on site. Something that I have to say was missing long before. Our country has gone through a significant political changes. Several initiatives have sent wrong messages to the market and created the delay in the launching of the national cybersecurity strategy that was chased by the federal government before, at least in the prior administration. But we do have, a number of developments since Mexico signed the new version of the free trade agreement with the NAFTA, or the so-called TEMEC. From a data protection perspective, there is a personal data definition included in the treaty with the U.S. and Canada. Each party shall maintain a legal framework that provides for the protection of personal information. The recognition of fundamental principles, I think this is key because Mexico has fundamental recognition of principles that the U.S. and Canada didn't to some degree. So that recognition, it's important for our systems. The compatibility of our systems, the protection of information, the adoption of non-discriminatory practices in the protection of individuals, and encourage cooperation between government agencies and investigation agencies across the region. In the same case, we have on the cybersecurity front, the development of capabilities with respect to national entities responsible for incident response, strengthen collaborative mechanisms, and encourage companies to use risk-based approach that rely on commonly agreed standards. I have to say that Mexico, over the past months, during COVID-19, experienced also a number of cyber incidents, cyber attacks. Anonymous Mexico reported hacking to the Conducef, which is Mexico's financial services consumer protection agency, and intends to do so again. We had a few cases in the past with hacks in Mexico to the central bank and a number of banks, Banorte, BBVA, and a number of banks in the past months and years. So there's a lot of activity in this end in Mexico, lots of companies making questions as to what they should do. As a closing remark, I would say just two things, and I'll allow my friends and panelists to share more if they have any final insights, that it is key to revisit the cybersecurity data protection programs that the companies have now at this time. In this digital transformation area, we need to see this thing not just from the prevention perspective, but from the product development perspective. What are companies launching in terms of apps? It should be be revised and by experts as the ones we have here in this group today. So to my fellow panelists and our keynote speaker, thank you so much for this program today. I think we had a great discussion. If you have any final remark, please, the microphone is yours. Otherwise, we'll close this event. Thanking everyone. And Jaime, please, can you turn to the last couple of slides, please, while we make give the microphone to our panelists. Now, final remarks from our panelists. Well, I just need to thank you again all and remind you that in Jones Day, we have created an international data protection guidance on coronavirus. It's a global initiative. We prepare a compilation of guidance published by data protection authorities. Of course, the EU is there, and Latin America. And in that link right there, you will see and you'll find information about what each of the agencies in the region has published in terms of COVID-19 initiatives. And let's go to the final slide and close this down. We have this slide that I think sort of enlightens a bit of where we are. we think that it's for time for you to come sit in the big kids table. The board of directors telling to the cybersecurity, expert. In Latin America, we can say that not just to the board, but at least to the IT department. In some instances, we know we were a little bit far behind in terms of cybersecurity, but now it's part of our reality. So welcome, IT managers, cybersecurity experts, lawyers, discussing on data protection and cybersecurity to the discussions, and we thank to our companies and friends, having the chance to webinars of the nature to have this level of discussions. Again, thank you to everyone. We are now closing our event at 11:32, and hope to do this again sometime soon. Thanks, everyone.
Thanks, everyone.
Thank you. Bye.